students joining us today for the IP Awareness and Patent Filing webinar organized by Soka Ikeda College for Women. We are honored by the presence of the esteemed resource person whose insights will surely enrich today's session. Women, we are committed to nurturing informed and empowered young creators, and your participation makes this program truly meaningful. With warm regards, we welcome each one of you to this enriching session. Now, I take great pleasure in inviting our respected principal to formally deliver the welcome address. Please, ma'am.
Thank you, Vinarisi. Respected guest. Am I audible?
Yes, ma'am. Now it's audible.
So, respected guest and resource person of today's event, Dr. BETKAR, the principal, the Global Village ACS College, Solapur, and our vice principal, and the HODs, the faculty members, and my dear students who have joined today. A very happy morning and a warm welcome to our today's session, the IP Awareness and Patent Filing, which is conducted by the Research and Development Cell with IQAC of our college, virtually. Sir, today we are very happy to welcome you, Dr. BETKAR, sir, the principal of Global Village ACS College, Solapur, to our webinar session. Sir, we have been trying you for a long time to be a guest for any one of our program, but this day is very fortunate so that you have joined us. And moreover, our R&D cell have been efficiently functioning by conducting more awareness program for both to our faculty and to our students. And today, we have gathered here for mainly to foster our knowledge in intellectual property rights and patent filing. So, and this program, surely it will create awareness among our staff and students about the intellectual property and the significance of patent filing and the strategies, what all we can use for this patent filing. Hope this program will be very beneficial, sir. Thank you for joining us. And to our participants who have joined today, please be encouraged and also post questions so that you can gain more knowledge by our expert, Dr. BETKAR, sir. So once again, on behalf of Soka fraternity, I wish you a very warm welcome to this webinar, and we are very fortunate to have you, sir. And my request is that once you have to come to our college in person to do the program. So soon we expect that also. Thank you once again, and I welcome all for this program. Thank you, sir.
Thank you so much, ma'am. I request Dr. Alamelu, Assistant Professor, Department of Commerce, to give introduction of our esteemed academician and our chief guest. Please, ma'am.
Good morning to one and all present here. We are honored to introduce Dr. M.M. BETKAR, Principal of Sri Kumarasamy Mahavidyalaya, affiliated with SRTM University, Nanded, Maharashtra. A distinguished physicist specializing in thin film technology, Dr. BETKAR brings over 34 years of teaching and research experience and has guided many scholars as a research supervisor. He has authored 30 plus research papers, holds 7 Indian patents, and has received several prestigious awards, including the Gold Medal in the Inter-University Research Festival, the Best Principal Award SRTM University, the Distinguished Principal Award IASR Kolkata, and the Best Teacher Award Dream IAS Center Solapur. His exceptional achievements have also earned him places in international, Asia, India, and OMT world records. He is the author of the book Simple Steps in SSR Preparation. A dynamic academic leader Dr. Becker has organized 1,300 plus national and international conferences and webinars and delivered 350 plus invited talks on IPR, patent filing, and MAC. He has also served as the keynote speaker in Singapore, Hong Kong, Canada, and the UK, and is a national and state level evaluator for the NCERT Inspire Awards. Active on LinkedIn and YouTube, he continues to promote academic development and research awareness globally. We are privileged to welcome Dr. M.M. Betkar as our chief guest for today's program. Welcome you, sir.
You, sir. Yes, sir, you're audible. Please.
Sir. Yes.
And the patent filing. I would like to share this PPT so that we can get something from that. I am not new for this institute. Before that, I have also joined here, and I am happy to join here today also. If any problem in the screen and audio, kindly inform me because I am not visible to you. Let us start the topic. In this topic, we would like to study, or we would like to see what is the types of IP, what are the types of IP. At the same time, what are the patentable and non-patentable innovations, and what is the procedure of filing patent, what are the benefits from the patent, and IP creations in teaching and learning and in the research. So with this journey, we will start first why IP awareness is important as a topic of this conference. Why IP is important? Intellectual property why plays a role, important role in our life? Because it encourages the innovations and creativity. Maybe student, maybe faculty, or maybe any person which is thinking about the innovations, and he can do the innovations, so it can encourage to the innovations. At the same time, it helps business to build brand identity. Our business is successful because of the innovations. At the same time, in our academics, it prevents plagiarism and counterfeiting the idea that tipped. Means if you create something, it cannot be copied by others. At the same time, it allows creations to make money from their work. Means after the innovations, if we do marketing of that, it gives creators to make money from that. At the same time, it helps consumers trust products and services. In the commerce faculty or any business one, if tries to create an IPR with innovations, and it gives a trust to the products, means we purchase the products, consumers can purchase the product because of the innovation. Let us see the meaning of the intellectual. In the word IPR, first letter is intellectual. Intellectual means what? It's the thinking of a mind. It's a natural thinking of a person which thinks something new or other. On the screen you are seeing that the person is thinking intellectually, means he wants to create an electric bulb. It's the intellectual thinking of that person. Now what happens? After thinking that creation of a bulb, he or she forms an electric bulb. At this time, this bulb is known as the intellectual property because it comes from its intellectual mind. Now what happens? If someone creates the intellectual property, then that intellectual property can be stolen by the others. It is a fear to copy to the innovation. At the same time, we have to do something that no one can use that technology, that idea without our permission, written permission to the user. So registration is important. Before registration that happens, someone can stolen our idea, someone can copy our idea, but after registration it gets locked. Locked means they have to take permission from us. So what are the intellectual property rights? Intellectual property rights are those rights given over the creations of mind to prevent others to use without the permission after registration. So creation is intellectual property is important. At the same time, registration is also important. Let us see the types of intellectual properties. There are 7 types. One by one we will say. Since first intellectual property is the trademark. What is trademark? On screen you are seeing that there are various trademarks from various brands that is known as Air India and Cadbury, Sony, Apple, the WhatsApp. So all these are the trademarks registered by the concerned organization, and they get the identity of that. Then what happens if someone creates a logo or monogram or a symbol known as the trademark? If it is registered, then what happens? What intellectual property gives? It prevents others to duplicating the logo. No one can duplicate the logo. This is the right of the first intellectual property of trademark. Second is the geographical indication. What are the geographical indications? These are the tags of the variety of the product. Means some state of some country is producing some various different products, innovative product that has the identity of that geographical area to that. So we can identify that the product is from that area. At the same time, our Tamil Nadu state has 69 GI tags, and it becomes India's highest GI tag. Our second highest means India, Tamil Nadu is second highest in the GI tag. What are the GI tag? GI tags are the tags given, registration given by the government for the products which are having the identity related to their geographical area. As like few words are there: Agrapeta, Basmati rice, Kanchipuram silk, Lasalgaon onion, Nasik Valley wine, Tirupati laddu. All these are the GI tagged products. The GI tagged products may be man-made or may be natural. On the screen you can see that Dindigul locks, Kandagi sari, and Tanjavur dolls. These are the latest GI tags given by the government of India to the Tamil Nadu state because of their uniqueness in the creations. At the same time, the Manika Malai, Kukumam beet leaf, and the Matti banana, all these are the natural and man-made products are identified as a GI tag given by the government of India to the Tamil Nadu state. So what it prevents? As the intellectual property, it preventing others from claiming the product. Means the product which is Matti banana is from Tamil Nadu. In Maharashtra, no one can claim that this product is of us because it is attached GI tag with the Tamil Nadu government or Tamil Nadu state, so that it prevents the others to claiming the product. Third intellectual property, design product. Means on the screen if you are seeing that there are simple design, that is coat button design or cup design or a chair design. These designs are unique and they can be registered as a third intellectual property. In case of the branded jewelry shop, if you purchase branded jewelry shop, then it gives the unique design, and that unique design cannot be copied by others. We cannot get the same design from other shopping, so they get the higher returns of the money because of the branded and uniqueness of that jewelry. Now the fourth intellectual property is plants breeder rights. Means if someone created a new plant if someone created a new seed, if someone created a new variety of a plant, that can be identified, given as a plant's breeder right. That is the fourth intellectual property. What it gives rights, what the rights associated with that? The rights are preventing others to use the plant without authorization. One cannot use that seed, one cannot use that plant without the authentic authorization of that person which was innovated. Now, fifth intellectual property is copyright. Copyright is very much related to us because we are from academic fraternity, and we produce some books, we publish some books, we write some articles, we create some poems. So all these literature media, musical media, dramatic media, artistic work, film, sound recording, this tangential media is always preventing or duplicating others to create the originals because of the copyright. So no one can copy of our literature, no one without our permission, no one can do the drama of our literature, or no one can record the audio sound of our poem without our permission. So this is the fifth intellectual property, that is copyright. Now let us see an example. There was a Operation Sindoor by the government of India before few months. So at that time, what happens? To give the name Operation Sindoor, 15 producers rushed to register the name of their unique movie. Means they want to give the name title to the movie, that Operation Sindoor, and they have filed 15 applications. So it is the important that to register a single name or to register a title, it's important to have to apply for the copyright. And sixth intellectual property is the semiconductor IC layout. Means in semiconductor integrated chips there is unique design, and that unique design can be registered as a intellectual property. Now important is the seventh intellectual property is the patent. Now let us see the definition of patent. Definition of patent is that it is a monopoly right granted to a person for a certain period. Means it is the monopoly right. Who grants? The government grants for a certain period, not a long life. It is the patent. Then who invented a new and useful article? The person who invents a new or useful or novel article, useful article, if it is innovative, it can be categorized as a patent. Or it may be improvement of an existing article. Means at every time we no need to form an innovate a new article, but we can add some existing article, some improvement in the existing article, that can be filed as a patent, the innovative part one. As example, before that there were diesel car, then petrol car, then hybrid car, and then electric car. So all these CNG cars, so all these are the improvement in the existing model car engine. So at that time it is improved and it can be able to grant the patent. Or a new process of making an article. If the article is same but process is innovative and different, at that time that process can be granted as a patent. Since if there is a tablet or a syrup or anything chemical or medicine which is having the same name, but the different innovative method for producing that medicine, that can be given to the patent. So patent depends upon three things: novelty, inventiveness, and utility. There should be a novelty, there should be inventiveness of that product, and utility is also important. If there is no utility, no patent is granted. So before filing the patent, we should need to record about the utility. On the screen you can see the example that innovative improvement can be patented, as I have said before a few seconds, that diesel engine. Such like on the screen if you are seeing that a wheel from stone, wheel from wooden, wheel reduced wood, and then tire, then tubeless tire. So all these are improvements, are the innovative improvements in the wheel, so that it prevents others by using, making, or selling that innovation without permission. This is the intellectual property rights given for the innovation. Now let us see the patent categories. There are three patent categories. One is utility patent, second is the design patent, and third is the plant patent. In three categories we can work. We can file the patent in utility patent, we can design a new so that we can get patent, or we can innovate a new seed or a plant, that is the plant patent. Now what is utility patent? These patents are mostly frequently granted. These are the machines, chemicals and process. So these are the complex stage of a patent. And then just a design patent. On screen you are seeing that there is simple needle, and when while threading of that we get so many types of problem. So one have invented a new design of sewing the threads, means we can sew the threads with the simple design that can be threaded very simply and very effectively. At the same time, the different cup designs, different goggle designs, all these are the simple designs can be applied for the design patent. Now similar but not same, this is the example of our kitchen. If there are two stainless steels on the screen, you are seeing that they are slightly different in their designs, but at the same time they have improved because of the utility of that, and it can be patented as a changed design 1 and 2. You are seeing the serving tongs on the screen. Now let us see the third new variety of the plant. This is a plant variety. If it is a new mutant, a hybrid patent, they can be granted for the patent. Now what are the patentable inventions? Let us see that all the inventions are not patentable, but which are patentable and which are not patentable, we have to see one. Let us see the innovations which are in the field of technology, from kitchen tool to nanotechnology chips. Mean the innovations starting from our everyday kitchen tool to the innovation nanotechnology chips, they all, if they are innovative, they can be patented. And the process of synthesis, any synthesis new method of making a chemical or making a tablet or making a medicine, that can be filed for the patent. And the software which are used with the hardware, they can be filed for the patent. Simple software not applied for the patent, it is the copywritten one, but if it is attached with a hardware, that can be filed for a patent. At the same time, the food recipes, chemicals, medicines or drugs which are innovative one, they can be filed for the patent. Now after seeing the patentable invention, let us see the non-patentable inventions. First of all, known inventions cannot be granted applied for the patent, because everyone is knowing. So that if you have published a paper, that cannot be granted for the patent after 6 months. Before the 6 months, you have to file the patent, because it is known to now everybody. Secondly, innovations contrary to natural laws. The innovations which are contrary to the natural laws cannot file for the patent. At the same time, the innovations which are against public ethics and morality cannot file the patent. Also, the innovations which are causing commercial exploitations, means your objective of forming a patent is the commercial exploitation, then the objective can be deleted and it cannot be filed for the patent. At the same time, the inventions which are harmful to animal, plant life or the environment. If innovation is harmful to animal life, plant life or to the environment and to the human life, it cannot be filed for the patent, because patent cannot go against our environment, against our human life, against our plant life. We have to take care of all that things. Secondly, the discovery of the scientific principles cannot be applied for the patent, and the substance obtained by just admixtures cannot be filed for the patent. Admixtures means what? Just they are mixed together, not reacted in between. As like our lemon juice, what happens in lemon juice? We just take water, sugar, salt and lemon juice, and we mix together. There is no any reaction in between that. At the same time, this admixture cannot be filed for the patent. And the plants, animals or any part of them cannot file for the patent, because the plants, animals are naturally born and naturally they are growing. We have no claim about our innovations or addition to that. So no any plant, animals or any part of them cannot file for the patent. And method of medical cure, means the method which is non-apparatus, means just a massage therapy, just a nadi pariksha, just a just a therapy which is without equipment cannot be filed for the patent, because it's just a method. And then the method of agriculture, horticulture, cultivation cannot be filed for the patent. It's just a method, it's just a knowledge. There is no equipment, but the equipments in the agriculture field, the equipments in the medical field are applied for the patent. Now, the traditional knowledge which is coming from coming to us from early generation, it cannot be filed for the patent because of the traditional knowledge. Now, atomic energy innovations cannot filed for the patent. Now, after the seeing that what is patentable, what are non-patentable, then let us see few examples of the patent. One example, simple example of the design patent is that anti-itching face mask, which is filed in 1982 and by Lucy, means it just a flask, just it is a mask to avoid the patient to eat in between. So the design is very simple. You can see on the screen that design is applied for the patent in 1982. At the same time, the patent on back scratching is also filed for the patent. In figure you are seeing that it is very useful equipment and one can need to purchase, so that the design, unique design of that equipment is filed patent in 1986. At the same time, let us see few tree climbing designs. They are on the screen, and these are innovative one, and they are filed for the patent. At the same time, in 1937, on the screen you are seeing that the first picture is of just a safety pin. Safety pin is, we can't think more of that because it is in daily use, but it is also filed. Safety pin is also filed in 1986, and Coca-Cola bottle is 1937. So simple safety pin is also filed for the patent. So no any innovation is not in low standard or high standard or very useful, but any innovation it can be filed for the patent just as like a safety pin. Now 1-4. 1-4 means which intellectual properties are interrelated to each other. On screen you are seeing that there is FM digital tuner, Philips FM digital tuner. Now after doing FM Philips tuner, we can take care of intellectual properties, means it is can be filed as a utility patent. This design is filed under the design patent. Also its name is filed under the Philips as a trademark, and the copyright means the music we are listening, the video which are watching, it is filed under the copyright. So one intellectual property is related to other 4 intellectual properties, so it is a 1-4. This is the 1-4. Now let us see the scene of Mahabharata. In Mahabharata, what happens that Arjun have so much of that attacked by the in the in this case what happens, our daily use elements, they are all related to our the intellectual property. Since first our hairstyle is also related to our can be created as intellectual property, since on the screen you are seeing that various different hairstyles which can be copywritten one. So from top to bottom we are related to intellectual property. These are the hairstyles. Secondly, glasses. The glasses we wear, that are also designed as a design patent. The various different glasses on the screen you are seeing that they are registered under the trademark and patent. And our shirt is also designed under the trademark and copyright. Different shirts are designs are registered under the copyright, and they are also attached with the trademark. At the same time, the type-in, just a type-in of our coat can be designed applied for the trademark and patent. At the same time, you are seeing that various hairpins from wearing from the women, they are different designs, unique designs, and they are also they can be filed for the trademark and the patent. You are seeing that kid sketch is the trademark. So various trademarks are there. And now we come to the pen, which is in our daily use. The pen, different models, different brands can be applied for the patent. That is, they have the patent of trademark and Also the tie which we are wearing, these are also having the trademark and copyright. On screen you are seeing that there are different tie and they are patented, they are copywritten, they are under trademark. Also the coat which we use, different coat, and that coat is also having a trademark and its copyright. At the same time, the simple buttons which are useful in the garments, so these are the various different designs. On the screen you are seeing that these different buttons are also trademark and they are the design patent. Now the time watch, the different time watches we are seeing here on the screen, they are also trademarked and the design patent from the product. At the same time, finger rings means any ornament can be designed for the unique product. On the screen you are seeing that the different ornaments are having different designs and they are registered under the trademark and the design patent. At the same time, the pant which we use wear, that is also under trademark and copywritten is attached to it. At the same time, shoes, they may be sandal or lady sandal or gents shoes, all these are the unique designs and they are marketed by creating their trademark and they are unique design patent. And belt, the belt are also attached with the design patent and they are having the trademark. So all these are things from top to bottom, from our hairstyle to the shoes, are already designed or they are able to file the patent and creating the intellectual property. Means no one part is left of us that cannot be filed for the intellectual property. So we all are the Bhishmas, as like the in Mahabharata. So I like this everything can be patented or copywritten as a intellectual property. Now let us go toward the filing of the patent. After seeing what is patentable, what is non-patentable, what are the patents type, and then we can go toward the filing of the patent. What the filing of the patent? The patent filing can be done by writing down our innovative ideas. If we have an innovative idea, maybe included in patent, maybe in the projects, maybe in paper, we have to write down this innovative idea in detail. Secondly, we have to check the patentability of subject matter. Before few slides we have seen that few are patentable and few innovations are non-patentable. So second step is that we have to check the patentability of subject matter. At the same time, if it is patentable, then we can forward or we can go for filing the patent. Now the step is the searching. Searching means what? If you create a paper, if you want to write a patent, write a paper, then we take the references from library or internet. Similarly, we have to search the similar patents from the available from the internet, and there are 5 search engines which are, there are more search engines, but these are the free search engines which are available for searching a patent. That is Google patent. In daily Google search, if you write just Google patent, then window goes towards the Google patent and we get thousands of patents on a particular innovation in the Google patent. Just a simple Google search, if you write in the Google search box Google patent, then you can get the different patents on different topics. Second is USPTO patent full text and image database. Thirdly is INPAS, Indian Patent Advanced Search System, is also the free engine to search the patents available in the market or in the internet. And also ESPCnet and World Intellectual Property Organization WIPO. So these are the 5 search engines. We have to search our innovations on that, and we have to give the references of few innovations which are available on the internet. How our innovation is different from the existing innovation. Then the innovation which is new one, that can be filed the patent after searching this. So there are thousands of patents, lakhs of patents are available in the search engines. So if someone want to file a patent, he or she can search this web search engine and can be referred as a few innovation. Let us see on the screen just a needle. Needle is having 207, more than 200 patents on simple needle. it is the picture of a search which I have conducted for the needle, then it gives me that there are more than 200 different types of needles available. Secondly, if we search the pen, pen word, then we get more than 2 lakhs of the pen designs are registered under the patent. Now, second step is drafting. What is drafting? Drafting is just a patent writing, but it has a particular techno-legal language. We have to write such that they can get understood by the patent examiners. And how to write it? If you search some few patents, if you read few patents, you get an idea of drafting of that patent. So second step is drafting, and third step is patent format. How it is drafted? It is drafted under these headings. What is the title of invention? What is field of invention? What is background of your invention? What is objective of invention, and summary of invention, and detailed description and drawings, and also the claims. They can be written in the particular format so that the patent format gets completed. What are the claims then? Claims are the things which you want to do intellectual property on that. That are the claims. Means if you form a pen and the design of pen, grips of pen, that color of pen, drawing of pen, all these things can be come under the claims. Now, the third step is sending. Where to send and how to send the patent. Patent can be submitted two methods. One manual method, one is e-method. Manual method means just downloading the forms, printing the forms, and then submitting to the post office on the particular address of the Government of India Patent Office address. This is the manual method. But nowadays people are preferring the ipindia.online.government.in e-patent filing system is also preferable. Without going out of our home, we can file the patent from our home or office. Now, where to submit? We can submit the patent in Mumbai, Chennai, New Delhi or Kolkata. Which judicial area you are residents of that, you can file the patent in that office. But all patents are processed under one roof in the one office, so that this is the provision to just apply for the patent. Now, patent filing forms and fees. Which forms are required for filing the patent? These are the 5 forms are required for filing the patent. One is patent for application for the patent is the fee of only 1,600. Then complete specification, no fees. Statement of undertaking, no fees. Request for fast publication is the 200 and 2,500. And request for the examination is the form number 18, which is compulsory one. And request for the fast publication is not compulsory. If you not file the patent under publication, fast publication, it get published, no problem, but it requires 2 to 3 years. It is listed under the queue. If you want to publish your patent speedy, then you have to file the application form number 9 with fee of 2,500. And request for examination form number 18, it is the compulsory one, because if you apply a patent, then we definitely hope that it should be granted. So for the granting, examination is compulsory one. So for that examination, we have to request for the examination. It is the compulsory one with 2,500. So there are only form number 1, 2, 3, 9 and 18 are required for filing a patent. Only 5 forms. Now, types of filing a patent. There are 2 types of filing a patent. One is the provisional filing. And what is provisional filing? Just after this webinar, after this seminar, if one want to file a patent on his name, register a title, then she can just write a title, abstract of 4 to 5 lines or maximum 1 page with form number 1 with fee of 1,600, and just the abstract if you send to the office, today you get the provisional submission of your provisional patent title today. But it is necessary to file a complete specification within 1 year from today, so that it can be granted. Means for complete specification, we need form number 1, 2, 9, 18 plus that fees, detailed drafts, drawing and sketches we have to attach it to it, so that examiner can examine your form and it is eligible to file a patent, patent can be granted. So you can follow provisional method, or you can go directly to the complete method as per your wish. If you file a provisional patent, then naturally we get an idea or we get a force to complete that specific patent within 1 year. So about patents rights. Patent rights are territorial rights, means if I filed a patent in India, then only in India I get the right. If someone using that technology in other country other than India, we can't do that. So these are the patent are the territorial rights, and the rights are only applicable in the country which it is filed. Now patent can be filed through PCT filing, a single application filing that gives a patent rights over 150 countries. Means for a researcher it is very hard to study the different guidelines of different countries. There are different fees. So without going to that, if you apply the patent, international patent filing through PCT, then you get the right over 150 countries. Now steps before the grant. What are the steps before the grant? Once we apply the patent, that is full specification to the patent office, there are few steps before the grant. First step is that our patent is published by the patent office in the patent journal every Friday. Patent office publishes its journal at every Friday. Then you can get your patent published after few days or few months or few years in the patent journal. Second step is that we have to wait. After publishing it goes toward the examination section. Examiner section studies all that and they send some queries to you. At the time we have to wait for the FER, first examination report. So first examination report we received within few months or years after submitting the patent, and we have to write the complete answer of the first FER. Means if you apply give the answer of the queries of the examiners raised by the examiners of the first examination report, if they are perfect one and they understood everything about your innovation, they can grant the patent. So examination decision is final one. If you give satisfied answer to your FER, then the examination examiner decide whether it is to be granted or not. The duration of maybe 3 years, 4 years, 5 years as per the decision of the examiner. Now let us see who can submit the patent application. In this seminar there are teachers, faculties, principal madam, and also students are there. Maybe some non-teaching faculties are there. If anyone think innovatively and create an innovative thing, that it can file a patent or create a IPR, and it gives credit to the institution which is affiliated, because the teachers, the non-teaching staff, student, those who have created the intellectual property, they get credit to the institution. And the applicant or true investigator can apply for the patent to the patent office. Secondly, the patent can be filed jointly, means under the supervisor. If someone are doing their research work and they get an idea of the innovation and they file the patent, they can file jointly the patent through the supervisor and the students also. And through the assignee, we can send our patent through our assignee also. If you don't want to go to the patent office, then you can give authority letter to someone to reach the patent office, and he or she can file the patent in your name. Also through an authorized IPR agent. If you are not knowing, if someone is illiterate one, if some person is illiterate one and he have innovation, then at the same time if he or she approach to the IPR agent, then IPR agent can help with some fees to file the patent. So these authorized IPR agent are the authorized persons. They have passed the examiner from the patent office and then they get the license to file the patent. So these are the authorized IPR agent. So there is no need of any qualification, no need of age, no need of any knowing English language or any language to file the patent. illiterate or literate person can file the patent. Now, unfortunately, if someone is dead after filing the or before filing the patent, then the legal representative of that dead inventor can file the patent also. Now our college is arts and science college. So what are the availability of the fields of the patents in the art and science field? Let us see. Let us see the arts field. Innovations, media production methods. If we do some media production of your teaching topics or practicals, and that media can be filed for the IPR or the instrument, then it is filed for the patent. Then new teaching methods with a technological component. If you use some technological component in your teaching field, maybe arts, commerce or science, that can be filed for the patent. Then interactive learning tools for literature, history or language. If you create some interactive learning tool to learn history or languages, all these things, they can be filed for IPR and the patent. And digital humanities tools, apps for heritage presentation, linguistic tools. If you produce some apps for to give the heritage information to the others for the presentation, few linguistic tools, they can be applied for the IPR, means copyright. Secondly, brain inspired spoken language understanding system. If someone developed a brain inspired spoken language English understanding system, that can be applied for the, if it is equipment, then it is filed for the design patent. If it is just a software, then it is applied for the copyright. Again, system methods for determining the validity of an essay examination. If you organize some examination, if you do some app to give credit to their students on different levels, so that software can be applied for the copyright. Then also method for cultural and heritage restoration. If any faculty or student from the art faculty, if he or she developed the method of culture for cultural heritage, that can be applied for the IPR. At the same time, AI tools for linguistic analysis. If you create some AI tools for linguistic analysis or to give a more dimension to the understand the language, that tools can be applied for the, if it is equipment, then it is applied for the patent. If it is software, then it is applied for the copyright. In science faculty, there is scope, unlimited scope to file the patent. Let us we think eco-friendly devices. There are few devices which are damaging to the environment. So at the time, if some student or faculty can decide to have an eco-friendly device, that can be filed for the patent. A process of manufacturing graphene, a novel equipment component that act as the insecticide or fungicide. If some students or faculties create new chemical compound that can prevent insecticides and fungicides, that can be applied for the patent. Also, the environmental solutions as like water purification technology. If some student or faculty created some water purification technology locally, that can be applied for the patent as a science. Same thing, biotech solutions. If someone produced the solution which is biotech solution, which is generally a engineered bacteria that can clean the oil spills, if simple solution, that can be applied for the patent. The synthesis or the method of that producing the biotech solution can be applied for the patent. Also, diagnostic kit for the human fever. If anyone designed a new diagnostic kit for to check the human fever, then that can be applied for the patent. At the same time, if some physics student is working on the renewable energy, so that can be applied for the patent. If he or she done a research in more efficient solar panels, if someone created some solar panel which is more efficient than existing, that can be applied for the patent. At the same time, the lab tools and sensors which are known as the low cost water testing kits. So all these science equipments can be applied for the patent. Means in arts and science, there are so much scopes to apply for the patents or to create the intellectual property. Now, what is the tenure of the patent? Tenure of the patent is 20 years, tenure of the copyright is 70 years, tenure of a design is 15 years, and plants builder right is also 15 years. But the GI tag and trademarks can be renewed. Its expiry date is 10 years, but they can be renewed after 10 years infinite times, so that the trademarks which are we are using in our daily life, that equipment, they are having hundred of years also history for that, because they are renewing them. At the same time, you might be having the question in your mind that what can we do with IPR. You are listening this seminar on IPR, then you might be thinking that what can I do with my IPR? If I create an IPR, then what can I do? So your IPR can be assigned, means your creations you can assign for organization, for a factory, for few years to take the financial benefit from that. Also you can sold your intellectual property to others for a financial benefit. Also you can gift your IPR to your friends. So at the same time, means what is intellectual property? So what the laws are applicable for the physical property, the same laws are applied for the intellectual property. Means as like physical property, we can assign physical property for financial benefits, we can sold the physical property for the financial benefit, and we can gift our physical property to someone. So all these intellectual property laws are related and parallel to the physical property, so it's known as the intellectual property. Now IPR infringement, next part comes if someone is duplicating your intellectual property. So at that time the term arises infringement. Infringement means copying, duplicating and selling that product without the permission of the author. If someone is duplicating that product, someone is unauthorized using that product and selling that product, so at that time such materials are known as the, such things is known as the infringement. So under IPC section 62, infringement can be instituted, so that in the district court we can apply the case of that infringement in the district court. Now on screen you are seeing that there are three products which are similar product but not same. OK Ole, Colgate and Bisleri. Means there are 4 Bisleri bottles which are similar. Means one is original, 3 are duplicate. In Colgate, first is original and second is duplicate. In OK, one is original and one is duplicate. So this duplication of the product is the infringement, and it is punishable, and we can apply a case in the court. A few things that on screen you are seeing some videos or some dance or some any media. At that time that producer avoids the mutes the sound of that audio, of the background audio, because the song on which is playing one, on which they are doing their performance, it is copywritten one. So that to avoid the copyright infringement, to avoid a case from the that producer, they are muted that sound and they are only dancing without the music. Now in the bachelor party picture, that FIR is filed against the Kannada actor Rikshit because the songs were from other person and they have used in their picture. So copywritten is very important. In case of trademarks, let us see, there are 2 examples. Fevicol versus glue is the famous case because the white glue is also producing the same thing as a Fevicol. The bottle was copied, the design was copied, and the consumers were buying the glue, white glue as like a Fevicol. So this was studied by the Fevicol authorities and they put 15 lakhs fine over the Premier Stationery which was duplicating the Fevicol and selling to the market. Now in the picture Janjir, you are seeing that it was published or broadcasted in the corona period without the permission, so it is also fined. In the picture Zhund, the Nagaraj Manjule, the director, which was also filed a case on him because of the story which was written by the picture, which is also having the copyrighted rights. On screen you are seeing that there is a story which is appeared in the newspaper, that dress designer Sunit was designed a dress for the Rani Mukherjee and Yash Chopra in the film, but she was used that dress in another program, and so that there was a file against the Rani Mukherjee and Yash Chopra of 2 crore fine, they have to pay because of the copyright. Because it was dress designer Sunet was said that it was compulsory to use within one function, not other without the permission. So it is the power of a copyright. At the same time, let us see in the any function we use that songs in marriage function, all these things, and people are dancing. So at the time, if there is copyright infringement of that, there is no copyright infringement, because government have allowed no copyright infringement in the wedding or any ceremony which is open to all, and which is non having no any tickets or no registration, not collecting any registration fees, that can be played. At the same time, let us see the rank of our intellectual property. The rank of intellectual property is the sixth rank, means people's India is now at the 6th rank in the world's statistical database. Before few years it was 7th rank, but it is now 6th rank. Now, why we file an IP? What is the importance of filing an intellectual property? Let us see. It gives a protection to our innovation. Secondly, it can be useful for transfer a new product with your innovation in the market. Also, it gives the reputation to the author and gains reputation. Means if your faculty is having more patent, if you are so that your institute gets the reputation of filing patent, at the same time the author gets reputation. It's third important. And fourth is IPR attracts the potential buyers. Means if you have innovation with you, then IPR can be attractive. Someone can approach to your institute, to that person, to purchase that your IPR, so that an institutional ranking gets improved. If you file more and more patent, if you create more and more intellectual properties, then our institutional ranking increases in the database of the state or national. So thank you to all. We don't go ahead without filing the patents, because we have to think our innovations which we are creating in daily or papers or book or any tools, and we have to create IPR, intellectual property, from that, so that we get the reputation, also our institution get reputation. And thank you to all. I have collected these images and videos from the information which are collected from the internet source. I am thankful to the sources, acknowledge to the sources. Now the session is open for the discussion. Kindly you can ask any question if you have in your mind.
Sir, thank you so much. Sir, could you hear me?
Sir? Sir, can you hear us? Hello, sir? Sir, hello?
Can you hear us?
I think he's on mute.
Yeah, Vinarasi, call him and tell.
Yes, ma'am. I'll check. Ma'am.
Incoming voice call from Dr. A. Vinarasi, Bangalore.
Ma'am. Okay. Just I have opened. Okay. I am audible, madam?
Yes, sir.
Thank you.
Now you are audible. Thank you, sir. Thank you so much for an elaborate lecture. Thank you so much. Sir, one doubt, one question. Shall I ask?
Yes, you can ask.
Vinarasi,
Sir, hello.
I think just call in.
Ma'am, I think,
Yes, I am listening,
yes, yes.
madam. Please, you can
Yes,
complete.
yes.
Okay, ma'am.
Sir, the thing is, for the science, in the science experimental procedures, after trial and error, can we, if we found any other procedure to be implemented easily for the students, whether it can be patented?
Yes, ma'am. It is an innovative one. You can patent
Okay.
that product and that
Uh,
method also, because someone is doing some other things.
yeah.
Means, if it is innovative, we can process the patent of that process. And if the tool is
Okay.
also innovative, then you can file the patent for the tool also.
Okay. Okay. Okay, sir. Thank you. Thank you so much.
I am thankful to all. Thank you to you, authority, all the and also Vinarisi ma'am for joining here. And I am thankful to all faculties and the students also.
Thank you, sir. Thank you so much.
Any other questions?
It was your examination period, so it was.
I think, I think we can close the session, sir.
Yeah. You can come.
Okay, ma'am. As we come to the close to this insightful IP awareness and patent filing webinar, we take a moment to express our heartfelt gratitude, our sincere thanks to Dr. Betkar for sharing his valuable insights, expertise, and inspiration with us today. His guidance has truly enriched and understanding and broadened our perspective. Your curiosity and engagement added great value to this program, sir. With these words of appreciation, I am delighted to invite Ms. Sneha, Assistant Professor, Department of Corporate Secretaryship, to kindly deliver the vote of thanks.
Good morning, everyone. On behalf of the Research and Development Cell and the IQAC, I take this opportunity to extend my heartfelt gratitude to everyone who made today's webinar an IP awareness and patent filing a grand success. First and foremost, we convey our profound thanks to our esteemed resource person, Dr. Betkar sir, Principal of Global Village, ACS College, for wholeheartedly accepting our invitation and sharing invaluable insights with us. Your enlightening session has truly enriched our understanding and broadened our perspective on intellectual property and the process of patent filing. I would also like to express our sincere thanks to our respected Chairman Sir, Secretary Ma'am for their continuous support, and without which such event would not be possible. A special thanks goes to our respected Principal Ma'am, Dr. Meera Murikesu, and Vice Principal Ma'am, Dr. Kanmani Subramanian, for your encouragement and constant inspiration in driving forward academic and professional development within our institution. My sincere thanks to our faculty members who actively participated and showed great interest. Thank you for your enthusiasm and encouragement throughout the session. And special thanks to our students who showed great interest throughout the session. Lastly, I would like to acknowledge the efforts of the technical and support team for ensuring the smooth execution of this event. Once again, thank you all, and we look forward to more such enlightening sessions in the future. Have a great day. Thank you.
Thank you, ma'am.
Thank you.
Thank you,
Thank
sir.
you, everyone.
Thank you for
Thank you,
joining
sir.
us.
Thank you, ma'am. I request the audience to switch on the video to take the photo. I request everyone to switch on the audience to take photo. Okay, thank you, ma'am. Thank you, sir. Thank you so much, sir.